So let's get straight into that issue this morning, which is with respect to the independence of the judiciary. And this was raised with two judges have argued that the Minister of National Security shouldn't be asking these questions, and this whole dispute over prisons visits and death row visits. Janelle, could you give some clarity over to exactly what the law suggests?
Okay, well, I want to quote directly from the law for this sort of segment. So when Madam Justice, the Honorable Madam Justice Gobin said that judges do have the authority to go in prison at any time, she was correct. According to the Prison Rules 1943, and I believe those are the rules that are still in force, ex officio officials are, judges are considered ex officio officials, right? Official visitors. And according to Section 11 of the rules, an official visitor may enter and inspect at any time any prison of the territory to which he has been appointed a visitor and shall be afforded full information on all matters connected with such prison and shall be given free access to all parts of such prison and to all prisoners therein. So official visitors can go anytime and get any information they want, and judges are, by their position, official visitors. So she was right, they could have gone. But the power to do that comes from the rules, and the rules were made, or the minister has power to amend the rules. If we go to Section 17 of the Prisons Act, Section 17(1) of the Prisons Act says the minister may make rules for the better carrying into effect of the provisions and purposes of this act, including rules for amending or revoking the prison rules, and make rules providing for, and it's a long list, A to T, and if we go to I, the powers and duties of visiting judges, official visitors, ministers of religion, and prisons aid societies, and that is literally the section that the judiciary quoted. Mm-hmm. So this act, the Prison Act, which is the primary legislation, empowers the minister to make and amend and revoke the prison rules as it speaks to the powers and duties of visiting justices, official visitors, ministers of religion, and prisoners aid society.
So that's the Prisons Act, right?
The Prison Act, yes.
So the old act that is basically giving the judges the authority to
Not
visit.
the old act, it's the rules.
Sorry,
rules,
the rules.
Yes.
Okay, it's the rules.
Right.
It's the same set of rules? Both of those things on the same set of rules or different set of rules?
Sorry, you could explain that?
I think he's asking you with respect to the 1943 Act.
1943
versus,
rules.
Right.
And we have
rules.
to be clear.
Right.
No, and I'm glad that you are actually, because as I said, yes, I'm not a legal mind, so thank you for clarifying. But 1943,
right.
This is what he's asking in relation to this A to T list.
Yes.
If they are the same.
If they're on the same...
They're not on the same level of force?
No, the same rules, the same document, the same...
They're not in the same document. The rules are not, from what I can see on the Digital Legislative Library, they are not necessarily attached to the Prison Act. But the Act there were rules in force before we came into the independence. Okay. These rules are still in force, but the Act is saying the rules can be made and amended and revoked by the minister. So the minister has that power.
Right.
To amend the rule. It's just that we have kept the rule that we always had. But the minister has the power, according to the primary legislation, to amend those rules.
But even if the minister has the power to do such, he has not done so. And is that where the controversy lies? Because he has not actually amended the rules. Is that where the controversy lies?
Right. Would it be that he has to basically amend the rules, or can he basically give instructions to judges?
But he's not, but that's the thing, the minister said he never gave any instructions, and
He inquired.
He just simply inquired, and to me, his explanation, if we take it at face value, makes sense. He said he just wanted to know the purpose, because he got an order saying that the judge will be visiting, but the order, one, did not speak to the fact that the judge had certain other judicial functions to finish in relation to the matter. It just says, well, he's coming, but he didn't know that the judge needed to come to assess the prison conditions in order to give damages to the prisoner. He didn't know that. He said, two, he wanted to put safety measures and make other necessary arrangements. And three, you are an official visitor. Yeah, you could come anytime you want, but you had media personnel who do not fall under the definition of official visitor. So he gave to me three very reasonable explanations or why he wanted that information.
You're right.
Can a justice or a judge, without notifying the Minister of National Security or even the Judiciary, could they actually go to the prison at any time, or notification has to be given?
You notify the minister, you notify the head of prisons, because I would think it's just more practical to deal with the prisons as opposed to...
The order went to the Commissioner of Prisons, and I think some of these things are out of respect and chain of command. If a judge is coming there, I could see how you would want to know why they're coming, so you can make sure they have as comfortable a visit as possible. I don't necessarily see it as, well, boss, you can't come here, no.
I think the problem is the Commissioner of Prisons, his letter to the minister basically said, well, is this visit even necessary? Something
he used the word purposeful. I think the word that troubled the judge was, is the visit still purposeful? And I could see on one interpretation, now again, media, we haven't seen the whole letter. We have heard a piece of the letter. So again, maybe the tone of the letter left us particular taste in the judge's mouth. So for him to feel like you are now stepping into or infringing on my judicial independence, perhaps. But the minister is saying, no, boss, is not like that, you know. I'm just inquiring.
Well, here's the thing. So initially, I just thought, well, look, Justice Seepersad, he's kind of going from 0 to 60 a little too fast. It's his interpretation. It is what it is. He got the visit. My issue was the judiciary's response, which, okay, fine, it's in the Prison Act.
The judiciary took the response straight out of the prison
right.
rules.
Which
the act, sorry,
which
the act,
was
right.
not, I don't know if it was reported to be from the act or if it was just reported as a statement.
I saw the
so I don't
clip.
know if
they didn't quote the act.
I didn't know if it was his writing that was at fault with that or if it was the reporting that was at fault with that. My thing was, I said it yesterday, I'm not going to walk it back. I have an issue with the act stating that. Now, granted, with regards to safety, I did say with regards to safety, look, you have to give that into consideration. I don't care what your duties are. You're going into no situation to get people potentially killed, including yourself, right? And I could understand with the media, as much as the media should be able to go in there for transparency. It's a prison, I can understand that. But I still have an issue with the fact that I don't like how it defines the capacity to amend the rules, that the minister has to amend the rules.
But why is that? What is the
Because
problem?
I don't think the act says with regards to, for the sake of safety or for things like that. It just says that the minister has the capacity to amend the rules. It's open-ended.
It says the minister can amend rules relating to certain things.
It's open-ended,
sure.
right? And, well, so the media person in me is basically saying how easy it is for a minister to say, well, no more judicial visits.
But you see,
because
why,
you can amend the rules
but why would we make the assumption that a minister who is a lawyer, in this particular minister is a lawyer, who would understand the concepts of separation of power, judicial independence, would make a rule that would infringe those principles?
Well, to a certain extent, Janelle, it's also the same way that we've made the assumption that the Minister of National Security was being genuine when he said he did it out of concern for safety. Because, I could interpret it in the sense that even though that sounds very good, it's an opportunity to see, okay, if the prison conditions are appalling right now, and this is what is it in respect to? It is in respect to a prisoner and
being kept in death row beyond the 5 years.
The problem is,
good.
Okay.
Yes. So the issue I'm saying is it's the same way that we're making that assumption that, okay, we're just doing this to probably try and ensure that the facilities, death row facilities, are actually, better than they actually currently are. We're going to try and fix up certain things before the prison visit, It's the same way that how we are making certain assumptions that there's genuine intentions. It's the same way other people could interpret it differently. And I don't give them wrong, given how things have always happened here in CNT.
The problem is, based on the nature of the case, right?
Yeah.
The minister who, if he understands separation of powers and all of these things, and if he's an experienced politician, he should understand how it looks when, you are basically saying, no, I have the right to not let you go. Right?
But the minister didn't say that. Well, that's the thing. The minister didn't say. The minister literally. Oh, okay. If we go according to the letter, just ask why you coming.
No, I'm speaking about statements made afterwards from the minister.
Which
where
he said.
One of my issues was he basically said, well, because he is he is in charge of the prison. It is well within my authority and purview as the minister responsible for national security to ascertain the nature of the visit. Now, he didn't quote the legislature, which
He
to
said
some
it's
extent
within his authority to ascertain the purpose of the visit, and we are taking it a step further to say he is saying he has the power and authority to stop the visit, and I think we need to draw that line.
The irony is based on, I could be wrong, but based on how the section of the act is worded, right? Granted, he might not necessarily be able to just stand in front of the justice and say, no, you can't go. But to some extent, he could amend the rules to more or less say that.
I don't know if amending rules are that easy, you know. It is still delegated.
Well, then it makes the whole exercise of him receiving the letter and asking these questions a moot point. Why did he do so?
I think what we need to understand, and I'm grateful, Janelle, that you brought a certain level of clarification and understanding as to what the rules are and for what the rules permit, and even the power of the Minister of National Security. I think we accept that and we understand that. I think the conversation also stems for greater separation of power, greater independence. But I do understand the context of which you're arguing.
And that is something I want to touch on, this whole concept of separation of power, but I know the time, so...
Yeah. The floor is yours. Please explain to us this issue of separation of powers.
Well, before I get to the separation of powers, in our earlier discussion, it seemed that there was some concern about the minister's ability to just change the rules.
Right,
So I wanted to make it clear. The rules are what we call delegated legislation, right? According to the Parent Act, the minister may subject to affirmative resolution of the parliament. So the parliament still has oversight of a rule change. The minister can't just wake up in the morning, go and scratch out one line and add another line of his own. There's a process that has to be followed. So we could remove that hesitation and reservation there. Does that help put that to bed?
Well,
Parliamentary oversight?
I have a question with
Yes.
regards, because how this unfolded, it seemed as though nobody took that into consideration, whether it was Justice Seepersad and Justice Gobin or the Judiciary and Minister of National Security. Because if it takes parliamentary oversight, it's a moot point. He can't necessarily stop you now for now. You can't stop him now for now. So I don't understand to some extent what's going on and what they're even debating for. But go to the separation of powers, because to me that's the crux of the matter.
Well, you would say that's the crux of the matter, but
well, for me,
Justice Seepersad sees it as a judicial independence question, which is slightly different. Now, the whole concept, as the layman would understand separation of powers, is that the three branches of the government, the legislature, the executive, and the judiciary, must exercise their authority without undue encroachment. Well, this is what it is, undue encroachment by the others, okay? But the layman or most people tend to think that there's this rigid, distinct separation of powers. But in many cases, it has been recognized that this sort of rigid distinction between the three arms is not one desirable or possible. There is an understanding that there may be overlap at times between the roles of the judiciary, the legislature, and the executive. So I want people to, when we talk about separation of powers, it doesn't mean that one can't sometimes, I don't want to use the word usurp, but exercise some of the functions of the other. We are trying to prevent the accumulation of all three powers in the hands of one person. That is what the jurist Montesquieu would say.
The research that you're arguing, it's not desirable for whom? You said it's not desirable or possible. It's not desirable for whom?
Well, according to the case law, my understanding is not desirable for the population that should be so. Because, okay, let's take an example. The legislature is supposed to be the rule-making body. The judiciary is supposed to be the interpreter of the laws and the rules, and probably be a check on the exercise of power by the executive and the legislature. But sometimes the judiciary undertakes a lawmaking function by either saying an act is unconstitutional or delegated legislation is ultra-virus and stuff like that, or even due to their interpretation, they make law. So in that way, they are then becoming a lawmaking arm.
We're speaking in the instance of case law now.
Yes, but that case law, we are in a common law jurisdiction where case law is law.
No, so I know, I'm just clarifying.
Yeah, so acts of parliament and case law are law in our jurisdiction. And then if we take the example of the executive, which is supposed to be the implementing body of the law, by delegated legislation, such as the rules, such as this act here, this section, which gives the minister the power to make rules, you have then now given the executive a sort of law-making role. So there are times when the three may exercise the function of the other. So that's why we're saying it's not desirable. Because if we were only to leave the legislature, for example, as the law-making part, rules and laws, it has been said it would take too long.
But if
it would take too long to develop the law any way it should be, so we would leave the executive to do the development in terms of rules and like regulations.
But if in an instance, you're saying that it's not desirable or possible, but if in an instance, and on the argument that it's not possible, if in the instance where it's just completely blatant now that there is encroachment.
But is there encroachment? I remember it's undue encroachment.
Again, I'm asking in an instance, without being specific to one example or one state. If in the instance where it is obvious, then the argument of whether or not it is possible goes out the door. Because if we're arguing based off of the examples that you've just given, which I understand, there are going to be times, okay, great, I can accept that.
Right.
But if in the times that we're directing it this way because we so desire it to be this way and we want it to be this way and so it's just blatant, as they're saying, tentacles getting into everything, then therefore we're not even trying.
No, but I think you're misinterpreting what I'm saying. What I said is that the rigid division is always not desirable and possible. And there are legitimate times when one will exercise the function with others. You are speaking to a time where it's not a legitimate exercise of one person's power by another. There are times when it cannot be done. Like when we come to judicial independence speaks to the fact that a judge must make a determination on a matter without any extraneous influence, threats, inducements. So in that regard, you cannot have a situation where a minister, for example, calls up a judge and say, hey, I hear you're making a decision on this matter, whether this contractor should be awarded $500,000. If you know what good for you, you go in his favor. Clearly that cannot happen.
Or it should not happen.
No, it should not happen. It cannot happen. That is not an example of where we could say, well, the minister could really call a judge.
It cannot happen
that
for
cannot
democracy to
happen
exist.
in that particular situation. So we have to just be clear. We just have to be sensible.
My thing is, given that I do believe this was to assess damages against the states.
Sorry?
This case, right, it was to assess damages against the states.
Yes, it was.
So, again, and maybe this comes back to my usual boogeyman when I criticize politicians with regards to communication. When a justice is looking, and if you didn't know what he was there for, then perhaps that's on Judge Seepersad himself. But when the case is with regards to assess damages for the state needs to be very careful in even hinting at the possibility, even unintentionally implying with the most innocuous of communications of, well, we have an avenue that we could interfere with that visit for that determination.
Yes, optics are important. Optics are important. But again, if we take the minister at face value, in this particular situation, he was saying, well, he didn't even know that there was any judicial function left. He's saying the order did not indicate that the judge still had to assess damages. That's what he's saying. So he's like, well, almost to say, well, if I didn't know, I would not ask. But
what does the order?
Well, I don't have it in front of me, but the newspaper...
Yeah, that's one of the questions, right?
One of the newspapers did, I think, quote the minister saying what the order did say, and then him saying, well, it did not speak to the fact that there was an assessment of damages left to be done.
In this case, I think this is, because we've seen where the judiciary can be a check and balance to some of the problems we have with the criminal justice system. So that's why I'm like, okay, that's where my concern is, because we've seen complaints, we've been a part of them with regards to, okay, the withdrawal of the list and how you're appointing a political appointee into the president. And, there's a lot of gray area there when you get down to it, because it's not anything illegal. But the unfortunate thing is you don't want to kind of wake up and be like, oh, what happened? When did we go from gray area to, straight into the red? And that's kind of how it goes if you don't ask the questions and sometimes kick up a fuss.
I just see this as an opportunity for education, for us to discuss certain things, delegated legislation versus primary legislation, the authority of the different arms of the government. I always see these as opportunities for education, and I wish we would take out this sort of antagonistic tone and seek to educate each other and the public.
You're sounding like you're antagonizing a situation there.
That's a passive aggressive antagonism, isn't it?
Janelle John Bates, it's always a pleasure. Good seeing you. And thank you for your time.
Good information.
And for good information, for clarifying certain things, because Sean and I don't know everything, and we know even legal minds.
Really?
So
I didn't get that impression. You all seem...
Really? we're doing it that well?
You're doing it that well.
Wow.
Really? Okay,
Yes.
good. Yeah, I used to like her, you know. Anyway, Janelle, have a good weekend and we'll see you next
Thank you,
week.
guys. Bye.
Bye-bye.